Judge, this is time and date set by the court for an in-person hearing relative to Mr. Moore for a proposed bond violation. Addressing the in-person issue, Judge, Mr. Moore played me a phone message that came from the court that should have been, I think the court just called the wrong number and left a message on his number indicating a hearing, but it was directed towards Ms. Butcher. And so he did not have knowledge that he was supposed to be here in person. Number two, I would ask the court, after talking to Mr. Moore, request the court, based upon the landlord-tenant matter that was before the court, I think last week or the week before, would request the court recuse itself and set this matter for a hearing before Judge Slavin tomorrow morning. We would be prepared to address the violations at that time. And Mr. Moore will be here in person.
Okay, well, I want to address that. We can set this for the morning. I don't believe that that's grounds for recusal on this case. Mr. Moore was present. There was a landlord-tenant case. His conduct at that landlord-tenant case occurred in my presence in open court on Zoom and on YouTube. And I don't know that anytime someone in a case, behaves poorly in a courtroom, that I should have to recuse myself. I don't know that that's the appropriate remedy. I certainly believe I can be fair and impartial on this case. I certainly have concerns with the allegations of the bond violations. But at this point, at this point in time, I'm not recusing myself from this case. I don't think it's necessary or appropriate.
Buckle up, guys. Today we are diving into the unraveling saga of Christopher Moore, a man who turned a simple bond hearing into a legal disaster zone. What began as a minor charge spiraled into a full-blown meltdown with judges, attorneys, and a long criminal past coming back to bite. This video sets the stage, and trust me, it only gets darker from here.
Looks like, what's that?
The landlord-tenant.
I have landlord-tenant. It ends around 10. My second batch is at 10:30.
I'm here all day, Judge, so whatever.
So Ms. Malden, maybe we'll just do it around 11:30.
I think there was another case.
All right, let's just make sure that there's something. I don't know what all we have tomorrow. 11 a.m. tomorrow. Well, Ms. Davidova was courteous enough to join us today from the prosecutor's office. This is not her docket. I'm guessing she's got another place to be tomorrow.
I do have court in the morning, Your Honor, tomorrow, but I can make like 11:30 work. I just circuit court sometimes is backed up.
I get it. Is that okay?
That's fine, Judge.
All right, Ms. Davidova, you're free to appear via Zoom. Ms. Butcher, you're to appear via Zoom. Mr. Moore, you're to appear in person.
Your Honor, before we go,
Go ahead.
before we go for the day, can the court inquire where Mr. Moore is presently?
My understanding is Mr. Moore checked in and told one of the clerks that he was out of state right now.
Mr. Moore is not commenting, Judge. He has a right to not say anything.
He's exercising his right to remain silent, Ms. Davidova.
All right. Thank you, Your Honor.
And Mr. Moore, just acknowledge that the hearing's at 11:30. I would like you here at 11 so we can talk, okay?
Mr. Moore, you're muted. Okay, I see a thumbs up, so it sounds like he understands.
Yeah, I had asked him to mute himself and not say anything, Judge, so that's a good, perfect response.
Okay, so Mr. Moore, we'll see you in person at the 23rd District Court. Your attorney is requested that you get here a half hour before that hearing at 11 a.m. All right, I'll see everyone tomorrow at 11 a.m.
All right, guys. Christopher Moore's first court appearance gets messy real quick. His attorney tries to spin a story about missed calls, but the judge shuts that down fast. Moore thinks prior behavior might get the judge kicked off the case. Spoiler, it doesn't. The tension builds when Moore refuses to speak, and the judge sets an in-person hearing. It's the calm before the storm.
Good morning, Your Honor. Jessica Davidoff for the people, P86743.
Morning, Your Honor. Jeffrey Fant on behalf of Mr. Moore. Judge, Mr. Moore has not appeared. I did try to call him. My call went straight to voicemail. I did check with security downstairs. He has not come into the building to their knowledge. I do not have an explanation for his non-appearance.
All right, and I would just note for the record, Mr. Moore was here yesterday and we set this for today so he could appear in person. He was advised at the time and the date on the record. He indicated he would be present. He's failed to appear. An immediate bench warrant will issue for his arrest. So if he's a flight risk, he certainly at least appears to be, based on the allegations, a danger to Miss Butcher. So he will have an immediate bench warrant for his arrest.
Thank you.
Okay.
Thank you. And Your Honor, for the record, may I note Ms. Butcher is present today on Zoom.
Thank you. I recognize that and I noted it on the file. So, okay, we are all set. And Ms. Butcher, I'm sure that Ms. Davidoff is advised you on what to do in the event there's any contact. And once he is located or picked up or turns himself in, the court will send you notice, okay?
So here's where Moore really starts to show his cards. He skips court again, probably because he knows what's waiting for him. The judge doesn't hesitate, bench warrant issued on the spot. The victim shows up, but Moore pulls a vanishing act. At this point, the court recognizes he's a danger and a flight risk. Things are about to escalate from bad to catastrophic.
Yeah, I can handle I'll do the arraignment, yes.
All right. I mean, he
Yes.
needs to be arraigned, and so, and then we'll let them know that we need yet another attorney.
Yes. I tried to explain to the client that I would schedule it with him so that we could talk at length, and that really upset him. I did
Okay.
explain that, I needed to go to the courtroom at this point and then speak with him on Zoom at a later date, but he wants another lawyer.
Okay, so let me call these the new one first. This is 241976 People versus Christopher Moore. So Mr. Moore, initially you had an attorney that was appointed through NDS, and they had the attorney they appointed was not I don't want to say qualified, but she didn't meet the standards under the Michigan Indigent Defense Commission's to handle a case of this nature. So she was removed from the case because she can't be on that list. Then Miss Watt was nice enough, kind enough today. She was called to stand in on this or come into the case forthwith so that you could have your court date. So I just want you to know what happened today. So now we have Miss Watt here. It was scheduled at 1:15. All we're handling today is the arraignment. So you're being arraigned on your new case. And I've known Miss Watt for many years. She is a very good defense attorney. And obviously those are decisions you can make, at least for the moment. But I am going to proceed with the arraignment. And then if you want different counsel, Miss Watt, it sounds like there's a breakdown.
Yes.
Okay. So, Mr. Moore, on this case, Ms. Watt, can I get your appearance for purposes of arraignment?
Yes.
If she's going to be.
Cora Watt, appearing on behalf of Christopher Moore, P41508.
Okay, so Mr. Moore, we can get you a new attorney if you want a new attorney, but I'm arraigning you on these charges.
Your
Okay,
Honor,
well,
we stand here to make the formal reading of the warrant on the charges, Your Honor.
Okay, so Mr. Moore, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearing. If you can't afford an attorney, one will be appointed to represent you, as Ms. Choate was, now Ms. Watt was. And it's my understanding now that, Mr. Moore, you want to fire Ms. Watt?
correction. I have witnesses in here. She was not listening to what I was finishing trying to say. I had to stop because somebody else, as you can see, there's other court proceedings going on here with several other judges, several other inmates. Got a basketball gym that we're holding court next to. I have cancer. I just had a seizure while I was in custody at Taylor PD when I was picked up. I sat in the hospital for 4 days. I was trying to tell her, she's trying to present an argument, and I'm trying to get her to understand, but then she's saying that she didn't have
This is where the story shifts from chaos to downright terrifying. Prosecutors drop a bombshell. Moore allegedly broke into the victim's house in the middle of the night, masked up, and flashed a gun. He tampered with cameras and left her in fear for her life. The courtroom hears it all, and the bond skyrockets. This is no longer just a legal issue, it's a full-on safety crisis.
just sitting here and I was explaining to her.
Okay, well, Mr. Moore, listen, Miss Watt was appointed to your case 2 or 3 hours ago. So of course she doesn't have discovery. She was just appointed, and that's not her fault at all.
It's clearly not my fault, ma'am. I was asked a question and I was trying to
telling you. All right, Mr. Moore.
All I was simply asking, just let me know when I can speak, please. So we're not.
All right, well, you have 2 dates within the next 21 days. The first is your probable cause conference, which is set for September 4th of 2024. Following that, you will have a preliminary exam. You are to appear in person at that hearing, and that is September 9th of 2024. And we will get this back down and have another attorney appointed to represent you. Mr. Moore, are you telling me that there's been a breakdown between you and Ms. Watt that you believe affects her ability to represent you?
I didn't
Yes
say
or no?
anything. She said that she was going to go back into the courtroom. This is what she said. I didn't even say anything. She said she's going back in the courtroom. Oh, this ain't going to work. I was like, what's not going to work?
I don't speak like that, first of all, Your Honor.
All right. Well,
Fine.
let me ask you, Ms. Watt, instead of Mr. Moore, Ms. Watt, has there been a material breakdown where you can't represent him?
Yes, Your Honor.
All right. So you're being removed from the case.
Thank you, Your Honor.
But I'm setting bond on this case. Now, he currently has a $250,000 cash surety bond on his other home invasion case. This one is certainly even more concerning. So, because now he's gone to home invasion first.
Home invasion, what are you talking about? When did this happen, ma'am?
Just when you think it can't get wilder, Moore fires his brand new attorney, mere hours after she was assigned. His meltdown continues as he blames everyone but himself, his attorney, the system, even his medical condition. But the judge stays focused and pushes the arraignment forward. Moore's courtroom antics are starting to look more desperate than strategic.
Moore,
Wait.
listen. You know what, Ms. Watt? I don't want there to be any confusion or anyone to say nobody did their job. So here we go. The allegations are that the date of occurrence is August 12th, 2024. And the witnesses state that on the date at that location, the defendant, contrary to law, committed count 1, home invasion, did break and enter or did enter without permission a dwelling with the intent to commit an assault therein. And while entering, present in, or exiting the dwelling, Shamani Butcher was lawfully present therein and or was armed with a gun, a dangerous weapon, contrary to MCL 750-110A, parent 2. That is a felony punishable by up to 20 years in prison and a fine and or $5,000 fine. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 2 is weapons, felony, firearm. The allegation is that you did carry or have in your possession a firearm, to wit, a handgun, at the time you committed or attempted to commit a felony, home invasion first degree, contrary to 750-227B. That is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 3 is weapons, firearms, possession by prohibited person. The allegation is you did possess and or use a firearm when ineligible to do so because he or she had been convicted of assault with intent to do great bodily harm, less than murder, and or uttering and publishing an offense punishable by imprisonment for more than 1 year, and the requirements for regaining eligibility had not been met. contrary to MCL 750224F, parent 6. That's a felony punishable by up to 6 years and or $5,000. Count 5 is assault with a dangerous weapon, felonious assault. And it alleges that you did make an assault upon Shamani Butcher with a dangerous weapon, to wit a handgun, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. That is a felony punishable by 4 years and or $2,000. DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750506A if the assault was committed in a place of confinement. Count 8 is weapons felony firearm.
There's
The
no charges on this, ma'am?
I'm still reading your charges. We're on number 6.
I'm sorry. I didn't mean to interrupt you, ma'am.
All right, well, listen.
Okay.
You want to know, I'm telling you.
Yes, I wanted to know.
Did carry or have in his possession a firearm, to wit a handgun, at the time he committed or attempted to commit a felony, to wit assault with a dangerous weapon, contrary to MCL 750227B. This is a felony punishable by 2 years consecutively, with and preceding any term of imprisonment imposed for a felony or attempted felony conviction, mandatory forfeiture of the weapon or device. Count 7 is domestic violence, and the allegation is you did make an assault or an assault and battery upon Shamani Butcher, an individual with whom you have a child in common, contrary to 75081, parent 2. This is a misdemeanor punishable by up to 93 days and or $500. A consecutive sentence may be imposed under MCL 750506A if the assault was committed in a place of confinement. You are charged as a habitual offender, and there is a 4th offense notice on your
This part is an avalanche of charges. 7 felonies are read one by one, from home invasion to firearm violations, and then it hits. He's a 4th-time habitual offender. If convicted, he's looking at life in prison. The judge lists every prior conviction, stacking up a timeline of bad decisions that led here. Moore interrupts, but this is the moment it all catches up.
And on or about 2/16 in 1996, he was convicted of the offense of breaking and entering a vehicle to steal property over $5 in violation of MCL 750.356A-B in Detroit Recorder's Court for Wayne County in the state of Michigan. And on or about December 9th of 1999, he was convicted of the offense of police officer fleeing 3rd degree in violation of MCL 750.479A3 in the 3rd Circuit Court in Wayne County in the state of Michigan. On or about 3/31 of 2000, he was convicted of the offense of assault with intent to do great bodily harm less than murder in violation of 750.84 in the 3rd Circuit Court for Wayne County in the state of Michigan. I'm not done. And on or about 4/26 of 2013, he was convicted of the offense of uttering and publishing in violation of 750.259 in the 44th Circuit Court in Livingston County in the state of Michigan. Therefore, defendant is subject to the penalties provided by 769.12. The penalty is life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty of under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. So that is the information alleging all of the charges, or stating all the charges that you have, sir, as well as giving you notice of that 4th offender notice.
Oh, I'm sorry. Are you done? Ma'am. Your Honor.
Sir, I just want to remind you, Mr. Moore, we're not adjudicating this case today. Okay, this is not a trial. This is not a trial.
I didn't understand.
This is an arraignment. At an arraignment, you are to see and hear the charges against you, which I've now read into the record. And the other purpose is to set bond and notify you of your next court dates. It's not the date where I look at all the facts and the evidence and make any sort of determinations. Today is specifically
because these are all
set
alleged.
bond. What's that?
Because these are all alleged allegations, right?
Absolutely.
Okay. That's why I was asking you, because was gonna say on August 12th, there's no way that possibly happened.
All right, well, don't say any more. See, now
No,
you're trying to
that's why-
talk to me
that's
about
why
the
I-
days.
That's why I asked you. That's why, okay, so don't say nothing now, because it's not the time to say it.
It is not the time, and anything you say can and will be used against you in court of law.
I'm not worried about it. I'm not lying about anything. I got nothing
Okay.
left. So that's why I was just asking what it was. So for the record,
Okay, so all right, so Mr. Moore, we'll get you a new attorney. The 2 misdemeanor cases are just going to follow the felony matters. So the 2 domestic violences will just go in and we'll work on those as your case proceeds through the 23rd District Court. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with Sharmani Butcher.
so there's no way of being able to talk to my son in any way, shape, or form either.
Sure, isn't the son at issue an infant?
Now Moore tries the sympathy card, medical issues, biopsies, seizures. But the judge isn't buying it. She marks his case for medical alert, but doubles down on the $250,000 bond. Moore claims bias. She calls it exactly what it is: public safety. After refusing to show up and harassing the victim, the court's patience is done. It's the moment the gavel really drops.
Can I speak now, ma'am? Your
You
Honor?
have a right to remain, you can speak, but Mr. Moore, what I'm trying to explain to you, and I want to make sure you understand clearly, is you have a right not to speak. And any lawyer.
I know I would choose to speak.
Any
I
lawyer
was just
would
trying to
tell
be
you not to
respectful.
speak.
Okay, I was trying to be respectful and not cutting you off. I was just waiting for my turn to say something.
Okay, go ahead. What do you want me to know?
Thank you. So, as I was trying to say in these alleged allegations, since I'm innocent until proven guilty, which unfortunately I don't feel like that's the case. However, I was just pointing out to the fact I need to have 2 biopsies and a colonoscopy. I don't know which treatment I can have in here due to cancer. Apparently now I had a seizure and I was hospitalized at Taylor Hospital, which is now known as Corwell Health, 3rd Medical Surgical East, where I had a seizure while being detained in Taylor PD.
Okay,
I have an abscess that's spread and the poison is spraying apparently in my jaw, going into my bloodstream as we speak. They're in the process of opening a new jail. I just went through my 4th round since the hospital of antibiotics. I'm developing an immunity. So they basically said, either the judge is going to either lower your bond or give you a personal bond and put you out on a tether, or we will when you turn around and either possibly.
okay, well, I'll tell you what, I'll make sure I contact the Wayne County Jail and let them know that your bond is $250,000 cash and surety. I've marked your file medical, but I'll make sure that they know
Sure.
that you are not eligible for release on tether unless you post that bond. I'll make sure they're aware of that.
Well, man,
And now the final nail. Moore loses his jail phone privileges for threatening the victim while behind bars. The judge makes it clear, his manipulation stops here. No more calls, no more excuses. His freedom is slipping fast. Guys, this was one of the wildest court spirals we've ever seen. Like the video, drop your thoughts in the comments, subscribe, and we'll see you in the next video.
All right, this is 241976 and 241796, the People versus Christopher Moore.
Good morning, Your Honor. Jessica Gabriel for the People, P86743.
And good morning, Tiffany Hall on behalf of Mr. Moore, P79667, appearing over Zoom.
All right, Mr. Moore, can you hear us?
Yes.
All right, so Ms. Howell, you've been appointed to represent Mr. Moore at the last court appearance. Mr. Moore was not able to communicate effectively or had a material breakdown with the attorney that was representing him, so you've now been assigned to the case. Today we had set an examination on 1796 and a probable cause hearing on 1976. So now, clearly you're not ready to hold an exam, but I'm going to suggest that we have a probable cause conference on both of these cases and set an exam date.
Yes.
Okay, so, Ms. Hall, I can assume, Ms. Davidoff, are you able to get her all of that discovery?
I am, Your Honor, but in picking a date for these cases, I asked that we set it for the 23rd because I know my officers should be available on that day.
Ms. Howell, does that date work for you?
It does, Judge.
All right, well, that is my lightest day so far. There's good cause. I have a new attorney on the case. These cases are intertwined, and I do think they should both be set on the same date. So the exam will be set at, and we'll just set them both at the same time. We'll set them at can we do 10:15?
Yes, that's fine.
All right, and I have a few others set that day. So Ms. Hall, if you could be on time, I only have the state prosecutor here until noon.
Okay.
So if we start right on time, we should be all set. I also, just for the record, and Ms. Hall, I can't send you these DSU reports, but there was a DSU report done on each of these files. The bond on both cases is $250,000 cash surety with a GPS tether. And the bond reports came back and on both cases, and they are recommending no change in bond.
Okay.
So after you have some time with Mr. Moore, if you want to make an argument, but I know you've not had a real opportunity to do that. So the bonds will remain in effect, and we will see everyone back. Do we need another probable cause date, Ms. Howell, or are you set just going on 9/23?
Judge, I'm set for 9/23.
Okay, and I trust that you and Ms. Davidoff will talk if there are any issues, okay? And then the two misdemeanor files, both are domestic violence misdemeanors, and they will just track or follow these felony cases.
All right. Thank you.
All right, we'll see everyone back on